thank you everyone for coming today. I wanted to start by just framing the discussion with the statutory mandate that is given to both the Minister of Health and to the College of Physicians and Surgeons and all of the professional regulatory colleges, which is to act in the public interest and to protect the public. So, despite some of the college's activities being about turf protection or that sort of thing, it is in the statute that sort of their key mandate is supposed to be to act in the public interest. And of course, inherent in professional self-regulation is this sort of social contract by which we give you the power to self-regulate and you act in the public interest and act to protect the public. And so one of the issues that has called into question whether or not the college is in fact acting in the public interest has been a number of cases around the sexual abuse of patients. And similarly, these cases of abuse against patients have called into question whether or not the Minister of Health is in fact acting in the public interest in this area and is doing enough to protect the public. And so it is, of course, essential that cases of abuse against patients be disciplined and followed up on promptly to ensure that patients are protected, but also to prevent the erosion of trust within the doctor-patient relationship. And so these headings from the news will no doubt be familiar with you, or familiar to you. So this news heading from the Toronto Star was a psychiatrist had been banned from practicing in the U.S. There were 12 counts of criminal sexual assault charges in the U.S. and against 6 different patients and 1 count of extortion. And nonetheless, this doctor was still practicing in Ontario. This was a case about a Burlington doctor who was accused of having intercourse with 2 patients. And before that allegation came up, he had actually been the subject of previous allegations where he had admitted to inappropriately touching patients and had served a suspension for that conduct. This was a case of a psychologist who had actually admitted to inappropriately massaging a patient and touching a patient, and eventually his conduct escalated, came to the college's attention, and after about a decade, he was finally suspended and brought up under criminal charges. So in a particularly egregious case against a psychiatrist, he had decades of consensual sexual relations with patients, non-consensual sexual relations with patients, and it was found that he had 10,000 photos and videos of female patients as young as 17. And again, this was a psychiatrist. And despite appearing before the college disciplinary committee 4 times and being suspended 4 times, it wasn't until very recently that the college admitted he was sort of not redeemable, not able to rehabilitate him, and finally took away his license. And one of the things that the college actually admitted was that one of the patients that he had quote-unquote consensual sexual relations with had just attempted suicide, and the college said her problems were not being treated. She has stated that she will never again see a psychiatrist, and she is confused regarding sexuality. His behavior has put her squarely at risk for self-harm. And this particular patient, he was only given a 12-month suspension for what had happened with this patient, and the college actually let him reduce it to 3 months because he agreed to undergo counseling and have someone supervise his practice. Another common kind of headline, which is that doctors have restrictions on their practice pending a disciplinary hearing. So in this case, a Mississauga doctor had to have a sign saying he could only treat male patients. That sign had to be visible in the waiting room. And his license had been suspended after he had put his mouth on the breast of several female patients. And so the penalty was this male-only restriction. So it's important to note, though, that these aren't just kind of bad apples or people who fell through the cracks of sort of the college disciplinary process. These are really part of a broader, more prevalent problem, both with doctors engaging in inappropriate conduct, but also with concerns about recidivism and whether or not the college's penalties are sufficiently strong. And in that regard, one investigation found that over the last 15 years across Canada, and this is a very conservative estimate because some provinces don't have 15 years of publicly available data, but 15 years, 250 doctors across Canada have been disciplined for patient boundary offenses. So this ranges from anything from sort of inappropriate comments or contact to sort of full-fledged sexual abuse. So that's a pretty prevalent problem. And again, these are probably underreported numbers. These are only the number of doctors who were disciplined, not those that they couldn't prove disciplinary complaints against or cases that were just completely underreported. More specifically in Ontario, over the past 5 years, 125 doctors have been disciplined in general. So not just for sexual abuse, but for any kind of professional misconduct or incompetence. 32 of those were for sexual comments or abuse of patients. And 17 of those doctors actually had multiple complaints lodged against them. So if they had multiple complaints lodged against them, you can imagine that there probably were, in at least some of those cases, additional patients. Only 10 of those doctors had their licenses revoked. And the college at any given time has around 20, 22, 24 complaints of this nature. So if you look at the monthly disciplinary schedule, they're hearing 2, 3 of these complaints every single month. So this is a fairly prevalent problem. So to delve in then a little bit into the college's disciplinary process and some of the problems in that process, this is the kind of trajectory by which complaints proceed through the college. So some form of detecting that there's a problem, an investigation, followed by a hearing, followed by a penalty hearing, and then of course an appeal. And so before I talk about some of these in greater depth, it's important to note that the Ontario College, due largely to some of these news reports, is actually proposing several changes at a variety of these steps. And the government has appointed a committee to also look into whether or not legislative changes should be forthcoming. And I will just say it's interesting that neither the college nor the government really did this on their own initiative. It was largely a series of exposés by the Toronto Star that led both the college to propose stricter rules and the government to appoint a committee. Okay, so the primary means by which complaints are detected is by what the college calls a consumer, or you may call a patient. Of course, there are underreporting issues by relying on patients to bring these kinds of complaints. Some patients won't know that anything has happened to them. They won't feel as though they can bring a complaint against their doctor. There have been cases where doctors have sort of threatened patients not to tell. So, due to these problems with consumer underreporting, there are also a number of mandatory reporters. So if a member, i.e., for example, another doctor, has reasonable grounds to believe that a fellow member has sexually abused a patient, that is to be reported. If the operator of a facility, so that'd be something like a hospital administrator, has grounds to believe that an abuse has happened, they're also a mandatory reporter. They have 30 days to file these reports unless there's reasonable grounds to believe there's some sort of imminent harm. And so that's the primary means by which these complaints make their way to the college. But again, patients would often underreport, and of course there's issues with peers reporting on their own colleagues. So, again, those numbers that we saw earlier are probably a significant underrepresentation of the actual prevalence of this problem. So, as I noted before, after after the complaint comes to the college's attention, there's an investigation stage, which is conducted by the Inquiries, Complaints, and Reports Committee. And what they're able to do at that stage is to make an interim order, either placing conditions on a doctor's certificate of registration, or even suspending that certificate of registration pending the full hearing, where it's likely that there would be a risk of harm to patients. And so the kind of restriction that's very common that you saw in the first slide are gender-based restrictions. So doctors can only treat patients of opposite gender of which the complaint was by, or that let's say the complaint was against a female patient, that there has to be a female health professional in the room. Other kinds of restrictions are signs saying, I can't treat female patients, or a requirement that the doctor tell female patients about the kind of complaints that have been made. And there's a couple of concerns with these kind of restrictions. I mean, first of all, with gender-based restrictions, there's a concern that, if you have the poor professional judgment to commit a sexual assault against any patient, I mean, do we even want you treating patients of the the opposite gender against who you committed the offense? So there's those kinds of concerns. But there's also huge concerns with oversight and monitoring of the extent to which these restrictions are actually being followed. And again, CBC News went to a number of doctors' offices where signs are supposed to be present, and they were either buried on a bulletin board, hidden among other things, or totally not visible at all. And the college themselves have had to subsequently discipline doctors they had already disciplined for not following these kinds of practice restrictions. And when the college has been pushed on this point, they'll say something to the effect of, we do monitor these doctors, we do have people whose task it is to make sure these restrictions are being followed, but not a lot of sort of firm numbers on how many people are doing this, how often they're checking up on these doctors, how they're checking up on these doctors. So there's a real concern here with having these interim practice restrictions in place and the extent to which they're being followed. So following that investigation phase where there may or may not be practice restrictions in place, that's when the hearing occurs. And so a hearing panel shall find that a member has committed professional misconduct if sexual abuse of a patient has occurred. And so that's the definition of sexual abuse from the legislation. So again, it ranges from behavioral remarks right up to intercourse. A couple of concerns with this hearing phase, and they primarily center around sort of the power imbalance that exists during the hearing between the physician and the patient. So during the disciplinary phase, the doctor is represented by the Canadian Medical Protective Association. And some of you are no doubt familiar with what has been called their scorched earth tactics, and what one might more politely call the vigorous defense they mount for their members. But it's not uncontroversial that taxpayers bear the bulk of nearly $200 million per year in CMPA fees that doctors pay to the CMPA to defend them. This defense goes not only to malpractice cases, but also to, of course, professional discipline cases. And even if these cases become criminal charges, the defense extends to that. So it's not uncontroversial that we as taxpayers are paying for the defense of these cases. And conversely, patients receive no real publicly funded representation during the disciplinary process, and are treated more as witnesses than as sort of parties. And similar complaints and concerns have been raised, of course, in the criminal law context. So there's a couple of different proposals that actually are coming from the college to enhance the role of victims. So the college is proposing that the government expand the role of victim impact statements, They're asking that victims be given standing on motions relating to confidential records. And they're asking for expansion of a victim compensation fund that exists. And these are, of course, important changes, but they still don't get at that fundamental fact that the victim is really a passive sort of witness to this proceeding, and doesn't have the same kind of representation that a doctor does. So following the hearing then is the penalty phase, and not uncontroversially, even if a finding of professional misconduct has been made, it's the college's practice to wait until the penalty hearing to impose that penalty. And so there have been cases where doctors, between a finding of misconduct and the imposition of a penalty, have gone ahead and committed another misconduct. It's up for debate whether or not the college could go ahead and award that or impose that penalty right at the point of the finding of professional misconduct, but the college is actually asking the government to clearly close that loophole in the legislation. So a bunch of different sanctions that are available to the college at this, if they found professional misconduct, not just for sexual abuse, but in general. So revoking a license, conditions on a license, suspending a license, reprimand, imposing a fine. In the case of sexual abuse patients, ordering counseling costs of the victim. So those are the sanctions that are available for the college to choose from. And of course, the criticism is often that what is chosen to be imposed is too lenient, given concerns, again, with recidivism, etc. There is, however, an exception to this, where the conduct is particularly egregious and falls under the definition of sexual abuse. It's actually mandatory revocation of a license. So for the most egregious things, it's in the legislation that the license be revoked. The college and the government both call this a zero-tolerance policy, but there are plenty of things that fall outside of that scope. And it's been the college's practice where activities do fall outside that scope that they don't generally revoke a license. So the doctor who, for example, that I mentioned earlier, who had admitted to either putting his face or his mouth on the breasts of at least 12 patients, didn't fall within that, and so the college defaulted to imposing conditions on his license rather than revoking his license, despite the clearly harmful nature of that conduct and sort of the repetitive nature of it. So what the college is now proposing, and which I think is certainly an important reform, is the college is proposing to redefine the categorization of offenses, and they want to be able to do mandatory revocation for anything that they deem sexual contact. I think obviously that's a step in the right direction, but importantly, anything falling sort of outside of that sexual contact will still be subject to their discretion and potentially get criticism of being too lenient. So again, the college is proposing that, but that would have to come from the government if they choose to enact legislative reforms. And again, for conduct falling short of sexual contact, the college still has that wide range of penalties available to it. And so if the college, even if more offenses fall within mandatory revocation, the ones that don't will still have the same concern that the college is imposing restrictions and they're not adequately monitoring them. And it's important to note that a significant chunk of these complaints are against family doctors, and so these are doctors who are often practicing alone, or with maybe one or two other doctors, and so there are significant issues with sort of monitoring these kinds of practice restrictions. Another change that has happened recently is that the college has developed a policy for reporting to criminal conduct, or potentially criminal conduct, to law enforcement, and the college has chosen to develop a policy on this. Not all self-regulatory colleges do this. So, you know, there is, if it was put in the legislation, it would cover other self-regulating health professionals. But the other kind of gap that exists with criminal reporting right now is that the legislation really only permits the college to report to the police the name of whoever the member is that's committing the offense. It doesn't permit reporting to the police of patient names, victim names, and so you know, obviously there's a tension here between sort of the privacy rights of victims and victims wanting to be able to disclose information to the college, but then the college then not being able to hand over that kind of information, which would clearly aid in the police investigation. So unless the victim has consented to the release of information, the college is currently just limited to telling police the name of the member or the doctor who has committed potentially committed the abuse. So a couple of conclusions then. The first thing is, you know, I've talked a lot about the College of Physicians and Surgeons, and that's because they're the ones that are in the news, and they're the ones who have been pushed to developing a variety of kind of policies in this regard, and they're the ones who are proposing legislative changes to the government. But other health professions have not done nearly as much in this regard, and so you know, even though we tend to focus on doctors, there's potentially patients of a variety of other health professions who do fall under the Regulated Health Professions Act, but aren't the beneficiaries of some of the policies that the college has voluntarily chose to implement. And so, you know, key to the government reviewing the legislation in this area is them deciding whether or not some of what the college is doing of their own volition should be put in the legislation. And if it is put in the legislation, then that protection would extend beyond just the doctor-patient relationship to the patient, any other of the 23 or so regulated health professions in Ontario relationship. So that's one sort of key area that I think is going to be important as the government decides what to do with the recommendations that will come down the pipeline from their own committee that they've appointed. Another issue, though, is other provinces. And so if we, again, this was data compiled by a media outlet, but what they found was of the 250 complaints against physicians with inappropriate behavior across the country, they broke it down by the nature of the conduct. And so, you know, some of these are obviously from Ontario, but a lot of this also happens across the country, and one of the concerns is that some of the other provinces actually have much less restrictive regulations than even those that Ontario currently has. So even though Ontario, I would argue, is falling short in many ways, other provinces are, many other provinces are nowhere near even where Ontario is. And so, you know, I think this is a good opportunity for the Ontario government to act as a leader in this area, and the Ontario College of Physicians and Surgeons, and hopefully some of what they decide to do, if they do decide to amend the legislation, is picked up elsewhere where the protections are much less strong. And then I guess a final point is that, you know, I focus primarily on this disciplinary process, which is very reactive, and you know, complaints go underreported. Many times there's numerous complaints before the college gets involved, and so that's a very kind of reactive process. I mean, ideally, we would be starting much further back in the pipeline and actually preventing these things before they happen. And so there are a number of kind of broader sort of cultural concerns inherent in the physician training environment and medical culture that I think need to be addressed here as well, to more proactively prevent some of this. And some of you will have seen the editorial that came out in the Annals of Internal Medicine in August 2015. This journal never publishes anonymous editorials, but they made an exception to publish an anonymous editorial talking about some of the sort of concerns with what goes on behind closed doors, in this case in an operating room. And so a couple of doctors told stories in this editorial, and one was talking about how he was a trainee and the attending was prepping a patient for a hysterectomy and commenting that, "I bet she's enjoying this." And he laughed. And he said he felt embarrassed after the fact. He didn't know what else to do. This was his superior, and so he laughed. This editorial prompted a number of other articles to come out about things that doctors had sort of witnessed and that were sort of normal in some ways in the operating room where the patient is unconscious. But the editors of the Annals of Internal Medicine, they said that we hope this essay will make readers' stomachs churn. So they wanted to sort of draw attention to these broader cultural problems. And they said there's a variety of ways that doctors can react. And in this case, the doctor had felt pressure to join in. But they said that even if he had remained silent, he would have robbed the perpetrator of an audience and discouraged that behavior. But then they said more importantly, they hoped that some doctors might actually, demand an end to this kind of behavior. And there was an example given of a more senior surgeon anesthesiologist who sort of turned to the surgeon and said, "Shut up." And so, so they're saying they want more people to do that. And so, in sum, hopefully the Ontario government takes this problem seriously. Much of what the college has proposed does go a long way to enhancing protections for patients, but there are still shortcomings. Hopefully, though, this will also lead to broader conversations in other provinces and, of course, also about medical culture more generally.
So I appreciate being invited to speak today. And when I talked to Lorian about what I could add, because I'm not an expert at all on the College of Physicians and Surgeons, she and I decided that what might be helpful is for me to talk about some work I'm doing in the context of university sexual assault and the challenges of having parallel processes with criminal law and an institutional process. And also talk a little bit about the culture right now in Ontario that might be driving some of the government's interest in reform in this area. But I also wanted to just make a couple of quick comments about the criminal law aspect of this, because I also teach criminal law. I know in my reading on this, when I was looking at a bunch of stuff that Lorian said to me, there's always this question about why there aren't more criminal prosecutions of physicians who violate the college's own policies, but are also engaged in what would be considered criminal activity. And I noticed on Lorian's slide that of the 250 cases that the CDC reported on over that 15-year period, there were only 19 criminal charges that flowed from that. And I think there's a couple of reasons why criminal prosecutions are particularly difficult. And this is obviously a bit of a superficial overview here, but I think in order to establish a sexual assault in criminal law, you need to have touching of a sexual nature without the consent of the complainant. And in the context of physicians and patients, obviously there's a lot of touching that goes on, and often touching of body parts that would normally be considered sexualized. And so that becomes a challenge in a criminal prosecution, because what you're really focusing on is on the sexual nature of the contact. And for women complainants who are the subject of physical exams where they're not really sure why parts of their body is being touched, it can sometimes be difficult to establish that it was done with a sexual nature, and that can be, I think, a challenge in the prosecutions. The other way that physicians can be charged with sexual assault is if they violate the trust or authority of the person that they have a patient-doctor relationship with. And those prosecutions are difficult. I looked up a whole bunch of cases, they have typically been centered around exchange of sex for prescriptions, is the way that most of those prosecutions end up coming down. And I think that's because that's a very clear violation of a trust and authority relationship when you are abusing the trust in that kind of manifest way. I think other kinds of relationships where physicians cross boundaries with clients and end up in sexual relationships with them that are simply inappropriate because of the professional relationship, it's harder for the Crown Attorney to prove that explicit violation of trust and authority. So the criminal prosecutions are haunted by the same issues with complainants that every other sexual assault trial is haunted by, and that is it's very difficult for complainants to come forward. The burden of proof is so high for the Crown, beyond a reasonable doubt. And in the case of physicians, I actually didn't know this until Lorian told me. I found this astonishing, but their insurer will defend them in criminal conflicts as well. So they have high-paid, experienced counsel in cases where we already know that prosecuting sexual assault is difficult. So that's, I think, something that the college, in some ways, can't do much about, because that is a criminal law justice issue. But it's a challenge, in the perception at least, of how seriously this issue is taken. But I wanted to mainly focus very quickly on what's happening now in Ontario around trying to make more serious our institutional responses to sexual assault. So I sit on the committee here at the university that is drafting sexual assault policy for the university. We are also, as the college is engaged in now, in a legislative regime. After March 8th, there is now legislation that requires us to have a standalone sexual assault policy. And when I was looking at this issue, I saw a lot of parallels between the challenges for the college and what we're now facing as a university. First of all, the Ontario government's response was expose-driven, just like the college is now having to deal with Toronto Star reports, and that's what's pushing its reforms. Universities had to deal with exposés by the Fifth Estate and by other news organizations that expose the nature of sexual assault on university campuses. So it's a perhaps unfortunate beginning and a reactive beginning to reform. We also, like the college now, need to have a standalone sexual violence policy with a process that accompanies it, a disciplinary process for students who violate the sexual assault policy, or sexual violence policy. And as feminists, and within the community at the university as feminists on this committee, we are arguing that the institutional nature of the problem be taken seriously. On the university campus, we call it rape culture, that sexual violence isn't just one-offs, it's not just anecdotal stories, but there's a cultural experience of sexual violence on the university campus. And I think that you're starting to hear the province describing this issue, not so much in the same broad sense for physicians, but this idea that the college needs to take seriously inappropriate sexual conduct as a systemic problem. That it's not just one-off doctors who are misbehaving, but that this is something that medical schools need to take seriously in the way they train physicians, and that the college needs to take seriously as a systemic problem. We have also had in universities, as there has been with the college, institutional cover-ups of the problem. So this fight to have a more transparent process, to have it be more open, both who is charged, how the process came about, and then what the discipline will be, is a problem in both contexts. And then certainly here at the university, we have been quite preoccupied with this idea of a parallel process to a criminal process. So when you have conduct that could be considered criminal, or that where the description of it carries the same stigma, and certainly being convicted of a criminal sexual offense is one of the most stigmatizing offenses to be convicted of. And so within the university context, we talk about the stigma that comes with violating sexual violence policy, and it would be the same within the college. And so, all of the protections that we talk about as far as due process for respondents add complexity to a sexual violence policy. And at the college, we've seen what has happened with the physicians' lawyers, making the process much more complicated and difficult for complainants. We're trying to avoid that in the university context, but there's this drive always to make it a more criminal-like process when you're talking about something that could be a criminal offense. And so that is a challenge. At the university, we have tried really hard to emphasize the public safety and safe learning, living, and work community of the university as the reason why we want to have a sexual violence policy. The same should be true for the college, that it's not about punitive actions against physicians. It shouldn't be primarily driven by punishment. That should be a criminal law matter. But instead, it should be focused on public safety and on trust, public trust in their physicians and in a well-functioning medical system. So if you can keep in mind the separate purpose of the disciplinary process, I think it can be helpful, but it's hard to keep that in mind. There's always respondents or the accused doctors, or in the university context, anyone in the university community who's accused sees it as a punishment and a punitive process. So we've struggled to keep the distinct mission of our university clear, and I think that's a challenge for the college as well. We also have confidentiality issues, and I just actually yesterday had a big discussion about this question of reporting to the police when you think that a criminal offense has happened, and what you do if that report is being done over the express wishes of a complainant who does not want to go to the police. Given what we know happens to women when they are caught up in sexual violence complaints with the police and then in the court system, I can certainly understand why women would be reluctant to go to the police. And but it's a big tension for institutions to figure out when to breach confidentiality, when public safety justifies overriding the wishes of a complainant. The college is in the process right now of trying to figure out that balance, and I think it's a delicate one, and it's one that they should be very careful around. We have tried to emphasize a complainant-centered approach here, where really the complainant's wishes do drive the university's response, but in the case of serial predators, the university wants to maintain its rights to override the wishes of a complainant, and I think that's going to be a challenge for the college too. And then finally, I was really interested in the sort of bystander issues that the college is dealing with, and wanting to train physicians to be responsive to sexual inappropriate comments or touching that they see in their colleagues. And we have poured a lot of money and a lot of time and effort into developing bystander training in the university context. And many of you will have noticed, I'm sure, there was a great ad that the provincial government put out when it launched its sexual violence programming, which is under the umbrella of It's Never Okay. And the legislation which passed deals with universities, but it also deals with a lot of other aspects of labor law and employment relations and occupational health and safety. And they had this great ad which all focused on bystander intervention, about speaking up when you're seeing something that you think is wrong, and condemning both what you see but continuing to intervene to stop it from happening. And so I think that would be something really, again, simpatico of what the province is trying to do with what the college is now saying should be its priorities. I'm not surprised that the college is facing legislative reform here, because certainly this government, the Ontario government, has made it clear that it sees sexual violence in institutions as a systemic problem across the board. And as universities were now legislated, there's been a lot of government reform on this, and so I think the physicians are going to be swept up into that impetus. So, I'm happy to take questions on anything related to those things. Lorian?
A bunch of great comments and reflections. I really enjoyed it a great deal, and I learned a lot from both of you, so thank you very much. I think you had a question.
Yeah, I was just wondering, in the college disciplinary process, is the college who's the prosecutor, correct? And the CMPA represents the doctor, and the victim is in this situation similar to the criminal trial. I just wondered what the role of courts was in terms of judicial review of these discipline committee hearings. Because I'm just imagining that the well-funded CMPA, if they think the college is overstepped in any way, are probably quite happy to appeal it to a court. And I'm just wondering what the college's kind of success record in terms of upholding its disciplinary orders is on judicial review.
So I haven't seen sort of real statistics on that kind of point, but it's my understanding, at least anecdotally, that in general, the courts. So college stuff goes to the health services appeal and review board, and then to the courts. So it's a long road.
Right.
And it's my understanding that not a ton of cases get appealed. I know people who sit on the health service appeal and review board. It's my understanding that not a ton of cases get appealed by doctors. That the college, at times will sort of reach consent orders or that sort of thing, and so the doctors tend to be happy-ish with the outcome, as happy as one can be, so there are appeals by patients, of course, but it's my understanding that not a ton of these do make their way all the way to the courts, and that the ones that do, obviously, deference to the Health Services Appeal and Review Board, and the Health Services Appeal and Review Board does tend to uphold the college's orders. So, so usually what the college decides kind of carries the day. I mean, again, I haven't seen hard numbers, but that's sort of the
I'm going to ask
story.
you a question if I can. I just wanted to unpack a little bit the idea of the college's duty around public trust and public safety, and your comments, Daphne, about the need to not have a kind of a culture of blame in the sense of criminalisation, but more trying to rehabilitate individuals. And I just wondered, do you think that is the same kind of culture that should be transplanted to the college, given the nature of the relationships between patients and physicians, which I would say is much more acute in terms of the vulnerability of a patient. As you heard, you can be unconscious on a table. You're often in quite compromising situations, and you really need 100% trust in what is happening. So I wondered if we could explore that a little bit, because my kind of view of this is throw the book at them. But your kind of take on this sounds a little more. I just wondered if you could explain that a little bit more, what you meant by that.
Yeah. So I absolutely think when it comes to conduct that would be criminal conduct, like so anything where patients who are unconscious or something that would qualify as a criminal sexual assault, I think is unforgivable when it comes to the profession. It should be an absolute mandatory revocation of sentence. And all I would say about other inappropriate boundary crossings is, if you start at the medical school, which they have very limited kind of conversations about this. It's not a big part of, my understanding is it's not a big part of what the medical school is focusing on. And that sort of training and instruction at the medical school, I think would be really important. And then I could see that being something that the college is, with especially young physicians in the first few years of their practice, might be a little bit more forgiving of. But any kind of systemic problem that a physician seems to be having, I think should be taken really seriously in terms of revocation of license. But that problem of the inappropriate boundary crossing is whether you can actually remedy that by some sort of remedial training or remedial, and I'm not a big fan of the gender restricted licensing. So yeah, I'm not sure what you can do, but.
Well, I was just gonna say, I think I also am on a little bit of the throw the book at them school of thought. I guess, some of the stuff that's, I guess, insofar as you could ever call it innocuous, but if it's a spectrum of sort of the worst to the least worst, some of the stuff with the comments, there's doctors hug or kiss, or there's one doctor who, massaged a patient, like some of that stuff, I think to sort of revoke a license in those cases, maybe is too far, but I think, if that's what they're going to do, and they're going to have all of these doctors that aren't getting their licenses revoked, then they need to take seriously the kind of monitoring and sort of the oversight of these doctors, especially since so many of them are in sort of sole practice or small groups. You know, so I think kind of part and parcel of this is maybe ramping up, you know, who they're gonna throw the book at, but then also, you know, if you're not going to, then they need to be monitored, because there are so many of these cases that did start out with some sort of touching, and then, you know, a decade later, like that one doctor, it went on for sort of 3 decades, and, you know, it does sometimes escalate over time, and so I think, you know, there needs to be more effort to kind of monitor and to stop it before it's able to escalate.
Lisa, yes.
Oh, sorry.
Yeah.
So I was wondering if you could talk a little more about what are the actual enforcement practices that are going on right now at the College of Physicians with doctors that have had these issues, because clearly from what you said about the exposés is that they're not doing a very good job, but what's actually set up?
Well, so if you ask the college, they'll say they have personnel. They won't really say how many. They won't really say sort of, is it that their whole job? How many people do it? Do they kind of rely on people tattling on doctors for not following the restrictions, or are they, you know, proactively going? Are they waiting for, you know, another complaint to arise? And so we don't have a ton of transparency from them. I mean, I think we should. I think if you're going to be self-disciplinary and you're going to self-discipline by having these restrictions, the part and parcel of that is demonstrable enforcement and monitoring of that. But we don't have a ton of transparency from the college on what's going on. We, you know, have anecdotal reports of people going and they're not being signed, or doctors supposed to notify patients of something and some patients saying, I have no idea. So, you know, but we don't know a lot from the college.
I think you mentioned briefly other medical health related, and I know natural physicians that fall under different rubrics, even osteopaths, but certainly those that don't fall under the college. I'm wondering if you have any thoughts or have encountered anything in relation to that nebulous zone.
There's not a ton written, and it's concerning, because, you know, in some ways you think the college needs to do more. They're not doing enough because, you know, they're the ones sort of in the spotlight, but all of these other health professions, there's not as much written in the academic literature. You know,
we know it's most likely to be a problem with dentists.
Yes, there have certainly there have certainly been complaints as well, but you know, things like massage therapists, all of these sorts of things, you know, we don't know a lot about. We don't have a lot of hard numbers, and you know, they in Ontario have a very similar kind of disciplinary process under the Regulated Health Professions Act, and so, you know, the kind of hope is that if the government is kind of prompted to take this seriously for doctors, then others would be the beneficiary of that, you know, any legislative changes that happen. But yeah, I mean, I think it's absolutely an area that warrants sort of further study and investigation, you know, the problems within some of these other health professions, especially since some of the concerns that exist with doctors most certainly exist with some of these other health professions. So if we talk about sort of the concern with the family doctor and often being one-on-one with the patient, well, that happens with physiotherapists, with chiropractors, with, you know, there's, you know, even to an even greater extent than, you know, a lot of doctors might be kind of a hospital environment with lots of other sets of eyes around it as well.
Sherry. Yeah.
I'm curious about the first part of the process that you outlined, Lorian, the detection. And what do we know about how much how these are underrepresented? Like what portion actually get reported, or what processes where do patients go? Like, do they call the college, or do they show up at the police station, or do they call, you know, the Providence Ministry and just ask for something? So about that, and whether or not there are any, has there been any attention given to looking at this, because it's a very problematic, you know, way. We know that from just assaults and inappropriate, you know, in other contexts. So I'm just wondering whether anyone's come up with anything creative to, or whether there's been any emphasis on encouraging patients to come forward.
Well, yeah, so it's sort of a mismatch of different ways that patients get there. I mean, some of them, you know, find it sort of online and go directly to the college, and, you know, the college does have sort of guides for patients, you know, guides about sort of what an appropriate or an inappropriate physical exam looks like, guides about the disciplinary process, you know, so there is stuff in the college's website that is relatively I don't like to use user-friendly, maybe it's a bit generous, but, you know, is reasonable, I guess. So some of the complaints get there that way. Some complaints get there, people go to the police sometimes will also say, can point them in the direction of the college. I've definitely heard of that happening. Some patients get sent to the college though by lawyers. When I used to practice, if we had somebody bring an incompetence issue, we would get them to go to the college first to sort of shake out some free evidence, if you will, just to kind of see what happened, get the story. So complaints can get there different ways. There's also patient groups that have resources for patients, and so there's all different ways that these complaints kind of come into being. But relying on kind of patients to approach or to make a complaint via any of these channels still probably is significant issues with underreporting for sure.
It's an endemic problem, it seems. But perhaps even worse, I would imagine, because people find it actually very difficult to find a physician as well, and so fears of losing your family physician may also play into this. Professor Chandler, and then
I was wondering whether one thing that could be done here, and this is completely off the top of my head, it may be wholly unrealistic for other reasons, but could one not, through legislation, say that certain kinds of clearly defined acts, such as sex with a patient, intercourse, whatever, that very clearly defined, so there would be no argument about what that meant, cannot be insured. Any claims coming out of that clearly defined behavior cannot be insured by the CMP. So restrict the scope of insurance for certain things. And could that be a way to try to discourage this kind of thing in a very kind of clear way? But it would not be stuff that is defined. So I think it would work. For example, I saw in your initial slide where you had examples, right? The psychiatrist, psychologist, the ex-psychiatrist, right? So I'm interested in mental health. Yeah. So this is obviously a high-risk scenario, in vulnerable people with problems, with repeated interactions between patient and clinician, and also in conditions of one-on-one privacy without all kinds of other people around, and situations of high emotional content as well. So very high risk. Could one not make a blue line? That's not what I mean. Bright line test that there shall be none of this between patients and that from doctor under any circumstances, and it will not be insured if any complaint emerges.
I love it when you let your inner Lorian economist out.
Well, so before I get to the insurance piece, I'll just say that the college, in addition to kind of the disciplinary stuff, they actually have a brochure on inappropriate relations, physician boundaries, something. Anyway, they have a sort of guidance that they have issued to physicians on boundaries. And one of the things they do talk about is psychiatrists in particular, because there are all of these sort of consensual relationships that happen in that context. And so, kind of even prior to this latest push for legislative reform, there was a similar push in the early 90s, and one of the things that came out of that was this sort of guide for physicians on boundaries. And one of the things that it says to physicians is, sexual intercourse, even if you think it's consensual with a patient, is mostly wrong. And there can be exceptions if somebody sort of transiently treats someone in an emergency room, but psychiatrist is not okay. And so the college has attempted to sort of issue that kind of guidance to physicians for sure. As you can see though, whoever's making that policy document in the disciplinary process aren't necessarily at sync with one another. As for the insurance issue, I think that'd be an interesting one. As of right now, the government has sort of left the CMPA mainly alone, which is interesting because they're sort of indirectly kind of footing the bill. They've left them alone almost entirely, let alone attempted to kind of carve out specific exceptions. I think. I don't know a lot about sort of the kind of psychology of deterrence in this context, and whether or not the sort of potential financial ramifications would be enough to deter someone from this kind of contact or not. Like I don't know enough about sort of psychology of sort of criminal behavior to know whether or not that kind of absence of insurance would. But I'm sure we must have that kind of idea of that data from other contexts. So. But I think right now, since this seems to be more college driven, which I think is what they want, right? Here's reforms we want, and then the government kind of reacts to what they want. I mean, and so the college isn't trying to sort of rock the boat with the CMPA. And they'd even, yeah, no, I think it is a good idea. I think it's interesting.
It sends a particular message
Yeah,
to everyone, really.
And also maybe even if it doesn't have a strong deterrent effect, it might at least put the physician and the victim on a little bit more of a level playing field in a criminal prosecution.
I'm surprised. I would think it would be hard to do that at the disciplinary process because presumably there's a presumption of innocence, right? That you couldn't deny the insurance just on the basis of the initial allegation. But I really am surprised that the insurer will defend physicians in a criminal process, because I would have assumed that would come after a disciplinary process where, and it's a much higher burden of proof. And if you've been found guilty at the college level, I'm just surprised that that I find shocking. But I could see why at the initial disciplinary level you'd have to have uniform representation.
Building on that, before we go to another aspect of that is why should the government continue to give physicians in these circumstances over? Okay, so that's the other. It's not paying for their net mal, but there's also should you be able to have an overhead number? That would pretty quickly solve some problems, perhaps.
Yes, excuse me, I just wanted to make a comment on this woman's question. I've been involved in the 3 task forces for the sexual abuse of patients, so from the early 90s, and one thing that has been suggested all the way through is that in every physician's office there should be a little brochure, like not hidden, not like their messages, and a poster that says, we belong to a college, here's what you do. If you talk to 10 people on the street, people don't know there's a college. You do. They don't know that that's there. So what we found is that when people finally realize that something has happened, they go to the rape crisis centers. They don't go to the colleges. They go to the violence against women, and they go online, as you said, to the patient groups. I mean, that's where they find it. And of course, some of those are international, so they may not know the provincial ones, but they can say, here's the jurisdiction you're in, and here's where you go. So it's, I think you have to go back to what the usual patient experience is.
Very helpful, thank you. Yeah. And there's a new patient ombudsman that's been created in Ontario, so that may be another fora for patients to go to initially as well, and that might help at least with some of this direct to the right place, direct people to the right place.
Yeah, as long as we know about it.
Well,
yeah, exactly. But I think the idea is that to make it more broadly known as kind of a valve for the healthcare system more generally.
And hospitals now, by law, have to have patient relations process, and so, hopefully, just as the patient ombudsperson would be pointing people to work for college, if something happens within a hospital and the patient, finds their way to this patient relations person, that hopefully things are kind of getting filtered, appropriately to the.
But I guess the thing is that hospitals, one of the issues here is the enforcement in all of these very small, autonomous little practices. These people operate independent, for-profit little, organizations all over Canada, dental offices, GP offices. The idea of having, how do you actually implement enforcement and monitoring? Well, it might be a good idea. I think you actually have to also calculate the true regulatory costs. And if you can't actually do that, then I think you have to rethink how you think about your sanctions. Because if it isn't simply feasible, unless you're going to, have some sort of electronic monitoring of what's going on, and then there are all the privacy issues and et cetera, the odd person who's going to drop in every 3 months, this may not be anywhere near it, and to do anything more than that may simply be just too costly.
Well, and so one of the other than sort of the gender-based restrictions or those kinds of restrictions that really need monitoring, one of the conditions that sometimes is imposed is a female health professional there, and I've seen it where the female health professional actually has to give an undertaking that she will write down every encounter and write whether she was there and actually submit that to the college. And so, whether or not that's foolproof, but at least the cost of that, 'cause presumably this is a nurse or somebody that the doctor's retained, at least the cost of that enforcement is kind of being redirected, towards the physician a little bit. But as you say, inspectors that show up every 3 months to see if you have a sign, I mean, that's...
the power imbalances within a physician's office with respect to that poor woman who has to,
Exactly.
be
And
every...
the contract of employment,
Yeah.
I'm thinking, man, like
Yeah.
worst job in the world.
Yeah.
Well, that actually is really, it's interesting because it's leading into my question. So clearly there's a strong gender element to the abuse of patients in the medical context, and we're talking about gender restrictions on who you can see and putting the onus on female nurses to do so.
Adult. Yeah.
Yeah, to catalog what's going on, and so how else is sort of the college dealing with or acknowledging or trying to deal with the gender issue of who is abusing who?
I haven't seen them really attempt to kind of address sort of the gendered aspects of it, either at the college level or even in medical education, which, recent sort of scandals have sort of illuminated. And so they really don't. I mean, I think they've kind of almost gone the opposite way to attempt to be as sort of gender neutral as possible, so that they're not sort of saying it's male doctors, female patients. And, at least one of those news clips actually was a male doctor and a male patient. And so I think the attempt has actually been to almost do the reaction's been to almost do the opposite. It's just, anyone can abuse anyone sort of thing, despite the fact that, the statistics suggest that, it is usually one gender on, and the other. They tried to be sort of neutral about it.
And I find that interesting because one of the challenges I think is to get doctors to be political about these issues, and my experience of lecturing in the medical school is that physicians like to see themselves as not political animals. So any attempt to get them to understand homophobia or sexism or racism as a political issue within physician communities, and how they have to work as a profession to overcome those issues, I run up against a brick wall, or at least that's been my experience, is that it's very difficult for them to see it as a systemic political matter. And so that's right, they revert to, this sort of formal equality model without taking into account the incredible gender nature of sexual assault, of course, always in society. Yes.
So in January, we had to talk about that dentistry scandal, and one problem that came up was in the university's complaint process, there was a risk of the university putting its own needs before those of the complainants and the accused. What has UOttawa done to try and mitigate that in its own sexual assault policy process?
Well, it's the struggle, right? Because in a university environment, we don't have the insurance problems that the physicians have, but what we have is a union problem. So we have unionized members, we have different unions on a university community, so we have in some ways the same sort of constituency problems of, it's not just, the university has its distinct needs around the entire community. There's a complainant who has her particular needs. And then there's a respondent who may be represented by, in a university context, a union, in the physician context, it would be an insurer. And so they're not always in sync. It's true. In the university context, what the legislation now requires is transparency. So the goal is to try to get the universities to be accountable by making what they do totally transparent to the public. I think in the college, and it's complicated with confidentiality, and with the college that is further complicated because there could be more than one complainant, and the details can be quite personal, right? So, yeah.
Okay, well, I want to, it's actually time for us to draw to a close, because there'll be a torrent of earnest young minds coming into this